adjournment. Malia, what's the story with this? Any problem? Just adjourning it with no set date?
We have no problem, but as Hannah has mentioned to me numerous times since the last meeting, the August meeting is off the table. And what is September? Or we just adjourn without date, it's up to you.
Not date.
Okay, adjourn without date.
I got that, a motion to adjourn, to grant the request of the expenditure of the town to adjourn without date. This motion by Dr. Bosch, President Ariel. Anybody opposed? Abstentions, show respect, opposed 0. So if you hear the placement of the sheet of town, it will not be heard tonight. Next item on the agenda is 7 Cedar Lane. Public, can you shut off the cell phones, please? Thank you very much. This is a public hearing for determination of potential environmental impacts pursuant 6 ICR Part 617 State Environmental Quality Review Act. The sketch plan approval with respect to the notification of Hank Grozzinski, 7 Cedar Lane, Muncie, New York, with drawing entitled 7 Cedar Lane subdivision consisting of a 2-lot subdivision with a semi-detached 3-family dwelling with 3 accessory apartments on lot 1, and a semi-detached 3-family dwelling with 1 accessory apartment on lot 2 and 0.4 acres. Property in question located on the south side of Cedar Lane, approximately 500 feet east of Dover Terrace, which is known as under Ramapo tax map as section 49.19-6-14 in an R15C zone. Okay, who's representing the applicant?
Good evening, Mr. Chairman. Terry Royce and Anthony Salentano for the applicant. Thank you.
One second, Terry. This, we have the affidavit adjourned, so this meeting matter can proceed to public hearing.
Thank you. The proposal is to remove an existing dwelling on the property and to create 2 lots. The property is located in R15C zoning district. Lot 1 is proposed to have a 3-family dwelling with 3 accessory apartments. Lot number 2 is proposed to have a 3-family dwelling with 1 accessory dwelling. Revisions have been made to lot 2 so that the unit is smaller. The rear yard has been increased from 15 feet to 20 feet, and the FAR has been decreased from 70% to 60%. And I think it would be good to keep in mind that the owner of the property, a lady, about 5 years ago, gave to the town an easement for construction across the property without any cost or charge to the town. She felt that the town had done so much for her that she wanted to give back. The construction and so forth did cause some issues with the property, but nevertheless she happily gave that, so I think that's something that certainly is a plus on her side. And I also understand that with the exception of perhaps one neighbor, all of the neighbors are favorable with respect to the proposal. As the agenda shows, we're here for secret determination, sketch plat approval, and referral to the zoning board of appeals for the variances that are required.
Mr. Burke, this is in an R15C zone. What is the lot? 3-family plus 3 accessory apartments? An R15C?
Lot width, they're asking for, are you asking for a variance?
Mr. Burke, that's all I'm asking. In an R15C, what?
62.5 is the mandatory lot width for a lot in an R15C. But in order to have a 3-family house, you need 75. So they're asking for a variance on, for I assume, for the additional 2 accessory apartments on lot 1. This one,
So they need a variance for the 1 accessory on lot 2. They don't need a variance.
No, lot 2, they're good.
Yes.
They don't need a variance. Oh, I'm sorry. Lot 2, they need a variance because it's less than 62.5.
For the street frontage.
How many, in R15C, how many accessories are you allowed? correct. You have here 2 lots totaling less than half an acre. And you want to put on 3, 6, 9, 10 units, 10 families. Is that correct? My math correct?
Yes.
This is a
10 families on less, on 4/10 of an acre. Is that correct? That's a little bit of utilization.
Mr. Chairman, just to refresh the board's recollection, at this last meeting, which was on June 7th, this matter was adjourned,
Right.
and at the motion made by Mr. Kahan and seconded by Mr. Colazzo, it was adjourned to this date. The applicant should look to reduce the number of units proposed, impact the proposed project on development coverage, and applicant would return to CDRC. So they did return to CDRC. They did decrease the development coverage, as Mr. Rice said, from, I think, 75 to 60. But they argued, based on their moving, and I'm not gonna put words in their mouth, they can make the argument, they increased the rear setback on lot 2.
Right.
But they did not, in fact, decrease the number of units, so we just wanted to point it out to you. We're not taking a position, just having to
You
point
say
it
they
out.
moved it, they changed it from .65 from .70 to .65,
0.60.
0.7, 0.6.
or .7,
0.6.
which one?
Lot 2.
Lot 2, which one, maximum development,
Sorry?
maximum development coverage?
They reduced it to 60.
Now, from .7 to .65, and that's like almost flat.
On the map, it says 0.65.
Right, it does, I was told 60, okay. Yes,
What?
66.
I can't hear you.
Yes, I see that.
It says it was reduced from 0.7 to 0.65.
So the whole application was brought back for half a point.
That, and also, we reduced the setbacks.
Increased.
You increased the setback.
Increased the setback
And
from
that's
15
on
to
lot
20.
2, right?
Yes.
From what to what?
But you did not increase, you did not reduce the number of units. Is that correct?
I'm sorry?
But you did not reduce the number of dwelling
Correct.
units. Okay.
We have a 7-item CDRC with 3 votes,
7 and 6.
and that's dated July 20th, 2016.
That was mine, but I had 6 items on there.
Mine, 7 Cedar Lane, has 7 items.
Both dated July 20th, okay. Okay, so let's go to the CDRC report. DPW letter of July 13th.
I'd just like to point out on number 3, this applicant's gonna have a great burden of expense to fix the sewer line that's there, that's servicing all the other neighbors, and I think we should consider that
Which item you talking about?
number 3.
Okay.
You know, we're required to reconfigure, resize our sewer line along our property downstream to alleviate the existing problem. That's the burden they're giving us. So we feel, take that into consideration when voting on this application.
I assume also you disagree with comment number 1.
It's just kind of an editorial.
Yeah, right, no, I just thought we wanted in the record, yes. So they disagree with number 1.
The engineer, we disagree with the engineering department's planning observation.
That's a nice way of saying it. You've been doing this for a while?
All other issues are addressed.
Okay, fire inspector of July 19th.
No issues with any of that. We have a fire hydrant right across the street.
Traffic department of July 18th.
We're requesting additional information on the plan.
Okay.
You're gonna give it, you're gonna give it?
Yeah.
Doesn't affect the secret, right?
No.
Doesn't
It's not-
affect
it
the
does not affect the secret.
the secret determination.
Rockland County Sewer District on one of July 18th.
Again, that was the improvements that we're going to do to alleviate the town's problems, and just give us details to follow. We have no issues.
inspection letter of July 26th?
I believe you did.
Building inspector letter of July 26th?
Stays up, correct?
There's a list of variances in that we need there.
Ramapo County Health Department letter of July 12th?
Must take an application for sanitary sewer extension, must submit to them the downstream sewer capacity and
Okay.
stormwater.
And Muncie Fire Department letter of July 9th?
They have no issue with that.
Update the building inspector letter to indicate revised location of building and lot line and reduction of maximum development coverage in July 7, 26. And that was done.
Yes.
CPRC notes that the only change since the June 7 planning board is increase in rear setback and reduction in development coverage. We went through that, scheduled July 26th. Okay. Let's get the CPRC report. Anybody from the board have any comments or questions on the application of 7C?
Last time we proposed, we spoke about it before, that we should reduce departments.
Yes, that was discussed. They did. Look at it again, and they left it the same. Any other comments, questions from the board?
Can you expand on the sewer issue that you're having?
Sure.
With the DPW?
Right now, the sewer is failing through our property. It goes from the sewer now goes from Cedar Lane through our property to Dover Terrace, down Dover Terrace. That line is failing. It's too small and not properly sloped. So in order to get this approval, we have to change that line from Cedar through down to Dover Terrace and then along Dover Terrace a bit to fix the problem. So this is a big burden and expense to the applicant. And that expense, we feel that some compensation with providing the normal number of units would help offset that great expense she's going to incur.
But didn't you say that 5 years ago the town came and we did the sewer line? You're saying that the problem is still
Well,
there?
what happened was they had an emergency break. So they allowed them to come in and repair to at least get things going a little bit. That's what she allowed.
Any other comments, questions from the board? Okay, this is a public hearing. Is there anybody from the public who wishes to speak on the application of 7 Cedar Lane? Anybody from the public?
Hi, good evening. My name is Kai Brzezinski.
Excuse me, speak to the microphone, please.
Thanks so much for taking the time to hear our appeal. My name is Kai Brzezinski, and I'm the applicant on this project. I'm a Muncie resident, from the town of Ramapo resident, so this is where I live. I like the place to be nice, and I like the place to be good. And for the benefit of the esteemed board members who were not here last time, I believe 2 of you weren't here last time, I would like to reiterate some of my points. I'm not coming here as a builder or as a developer. I'm just a private person who would love to have my children live near where I live. We lived there for the last 16 years. And besides for that, as far as I know, we are not aware of a single neighbor objecting. And oops, I'm sorry, I forgot my papers. I would like to hand everybody papers of all the neighbors, front, back, side, all around, surrounding. Everybody approved. On the contrary, not only did they approve, they all actually gave us we'll gladly let you do it, we'll happily let you do it. So our neighbors, they signed a note and they want us to go ahead with that. Thank you so much. Our neighbors, actually, one of them were gonna come to represent us, but the timing wasn't right. Several of our neighbors said, we'll come, and we're like, it's not necessary, we don't have anybody coming to object. As the town of Ramapo just heard, it was approximately 5 years ago that we had our place ripped up for the whole entire winter. Our driveway, our property, our swing set was removed, and this is, without any compensation, we didn't ask for any money, we just felt that it's for the town of Ramapo's benefit, so we allowed it, and we allowed it again this past fall, where they ripped up our driveway to do some repairs, and it seems like whatever it is that they repaired must not have been done properly, because we're being requested to do it again on this, but to do it properly this time. And besides, we are giving the town of Ramapo does not have easement rights on our property. There's nothing recorded. And we are giving this to the town of Ramapo without any compensation, so we feel that that would be beneficial to the town of Ramapo. We would like the town of Ramapo to approve what our project is. Regarding the apartments, the amount size, lot 1 was, last time we were told that was okay. Lot 2, it was recommended. As far as I know, it was just a recommendation. I didn't, we just were told as a recommendation. We did reduce, we made it 20 feet from the back, and we reduced the coverage. We made the whole building smaller. We left space for ample play and recreation area. And we also are consistent with what is in the neighborhood already. This is not what's been approved across the street and what has been built surrounding us. This is not something different than what the neighborhood looks like. So pretty much, and I would really appreciate if the town of Ramapo would take into consideration that all of our neighbors are in complete approval, and that we have been so gracious to the town of Ramapo without any compensation. We didn't ask for anything in return, and we weren't aware at that time that we would even ever consider building. It wasn't something we had taken into consideration, oh, we'll want their help eventually. It was just because we wanted to help town of Ramapo, and we did shrink the development coverage. We made the building smaller, and it happens to be, if you look at your plans, some of the places where there's buildings were not, I don't want to go into the trees, so it's going to be smaller than the actual thing is also. But since the plan, we don't have the actual blueprints, because we don't know what will be approved. That's why we, you have everything, it's going to be worked out to be a little bit smaller than it actually is. Thank you so much. We really appreciate you taking the time to consider our appeal. We would greatly appreciate if you would consent. Thanks a ton. Have a good night.
Mr. Brzezinski,
Yeah,
can
sure.
I just ask you a question, please?
Sure, go ahead.
If I understood you correctly, is it your intention to build these units only for your children? Let the children have a place to live?
Well, I have 6 children, Leah and Cara. I can't imagine all 6 will live in this house, but I would like for my children, we like this neighborhood, we want to live in this neighborhood, and we would like for our children to be able to live here. And since we live right here, we would very much like to, we're going to move a few blocks away, and we're going to live right there, and our children will be able to live right here. And that's the only way we can build, if we get out of the house.
So you don't need 11 units for your children?
No, I don't need 10 units for my children. I would like, as the board knows, you're aware that it's very, very costly to build, and I would like to be able to have a little bit of a rental income to be able to supplement some of the costs. And we are giving the town of Ramapo, actually we're building even on lot 1, 15 feet as opposed to where most people build 10 feet, because we're giving the town of Ramapo the easement of 15 feet there, so that the town of Ramapo can get in whenever, look, we're going to fix it now, and if ever in the future that they have the rights to it, now we just graciously gave it, but, sometimes people do object, and then, they have to start fighting in court. We were very, very gracious, and we helped the town of Ramapo twice in the past, and this time we'll obviously help with fixing whatever it is when we build. Thank you. Any other questions?
Thank you.
I appreciate it.
Anybody else from the public wishing to speak on this application of 7 Cedar Lane?
I make a motion to close the public hearing.
There's a motion by Dr. Bash to close the public hearing. Is there a second? Seconded by Warren. Anybody opposed? I got the picture right there. What's that? One of the things. Anybody opposed? Any abstentions? Opposed passed 6-0. Okay, next deck.
We are recommending negative declaration.
No problem.
Okay, can I make that up on page 4?
Can you what?
Can I make a proposal?
motion to grant on deck deck. There's a motion by Yaakov Rush. Aye.
Even though I believe it's a little over-utilized, however, being it's the neighborhood, what the neighborhood looks like, and nobody could complain against it.
Well, that's not the issue.
That's not the deck deck, don't put on deck deck.
So I'm making a motion to make it.
To grant the deck deck. We have a second. Second by Jose. Right? Jose, I got you right this time? Anybody opposed? Anybody opposed? Yes?
Yes.
Okay. The abstentions? Shows passed 6-0. Okay, sketch plan.
So I'd like to make a motion to deny. I think that it's a little bit of a mockery for the applicants to come in with the exact same proposal, taking it down by 0.5. I really believe so. I mean, we take the time to come out, we take the time to look, we take the time to make a site visit, we take the time to read the maps, and I think it's a mockery. I don't know, like, when is this going to end?
But that, with all due respect, that's the basis, but you need, if you're gonna deny sketch plan, you have to deny it, not because the applicant
That's
didn't
fine, I'm
respond
just
to your
saying
request.
something, I'm just saying something.
Okay.
Okay, and, so my reason is because the town engineer has written that proposed dwelling sizes would create overutilized lots. I understand that the neighbors themselves have no objection. Most of them are tenants, they're transients. You look at the list that was just given to us of neighbors, they're not all homeowners. A few of them live in the same block, unit, and of course they're just renters. So, renters don't really
With
have
all due
objection.
respect, how do you know? Do you have personal knowledge?
No, they can't be both the you mean
No, I know.
owners?
There may be,
Owners.
that you can't assume that everybody is a renter. There's
Each of
nothing
these
in the
units are
record. I will
owners.
lose that case in a minute if you say it's because of renters.
All these units are owners?
I'm not saying that, but you can't say that the people are tenants and therefore, of course, they wouldn't have a
Okay.
position.
I'm
That's what I'm
sorry.
saying. You have to have a basis in the record.
Erase
And
that.
with all due respect, there's no discussion. All we have is a list of, they don't say, they just say they're neighbors. And you have
They
Cedar
just say
Lane,
no,
Cedar
they don't say
Lane,
unit
blah, blah.
number or anything else. Right, okay, scratch that, my mistake.
No problem.
Okay, but there is an overutilization, and the fact that, the neighbors don't care, it's the traffic coming out into the main arteries, we're backed up to, the 06 cannot even handle what we have, they're naturally gonna come out, and that is why unless the applicant wants to take off some of the units and bring down maximum, the town, in its plan, gave guidelines, and they said 0.55 is maximum development coverage. They stretched it out as much as possible. Why an applicant is going over, I can't understand, and they don't even have anywhere near the amount of lot area, so bring it all down, make it fit, build what you can, and then it will be a beautiful project.
I know you closed the public hearing. Can I be heard, Mr. Chairman?
I'm sorry, I didn't hear what you said. I didn't hear what you said.
I'm sorry?
So basically,
You didn't hear me, and I didn't hear you. Okay.
Oh, I said, I'm sorry. I said, I know the public hearing has been closed, but can I be heard on those points?
Yes.
Thank you.
Huh? You should have spoken before. I'm sorry, go ahead.
Thank you. If I may, I mean, a couple of points. I mean, first of all, that rationale is based in large part on a comment from the town engineer, and as I jokingly said before, that's the town engineering department's planning comments. I mean, that's really not appropriate. Your planner hasn't raised any similar objection. In fact, has recommended a negative declaration, which this board has adopted. So I think in the first place, premising that on a comment from the town engineer is kind of outside of the scope, particularly when you have a planner who's come to a contrary conclusion. There's nothing in the record to substantiate the conclusion that was offered with respect to traffic, and the fact that an applicant is proposing to be referred to the zoning board of appeals for variance variances shouldn't really, in my opinion, be a basis for a denial, because that's what the zoning board of appeals is there for. If people didn't need variances, you wouldn't have a zoning board of appeals. So I mean, I don't think that's necessarily a valid basis. And also, if you can remember, I mean, sketch plat, and I'll ask Mr. Berman if the board's interested. I mean, sketch plat is really just for the general layout of the subdivision. I mean, I think it's such a fundamental, basic approval. All you're really talking about is a layout and the street, and that's pretty much what sketch plat was. So thank you for hearing me on that.
I have a question. Are we supposed to regard the letters from the town of Ramapo on the public works as laughable?
No,
Oh, okay.
he never, with all due respect, Mr. Rice did not say it was laughable.
No, I didn't.
All he was saying is DPW gives engineering report, and Mr. Moran put in what Mr. Rice calls a planning comment as opposed to an engineering comment. That's his opinion. You can use it for whatever, if he's making an argument, you can do. You're not to disregard it. That's what the professionals are there to do. He's just saying that's a, not gratuitous, but that's a beyond the scope what he normally does, which is engineering comments, drainage, sewer, et cetera, and it's not. But you have the right to, with all respect to Mr. Rice's opinion, you have the right to consider it in whatever motion you make.
And I certainly didn't call it laughable. I frequently joke with Ed about him going out, what I consider going outside the scope of this thing. So it's not something I'm making light of him or his adherence to what he believes his job to be. But the point I made is just the point I was trying to make.
Okay, there's a motion on the floor to deny sketch plan. Is there a second? I don't see a second. Anybody want to make another motion? There's a motion on the floor. Huh?
So I'll make a new motion that
One second. He's got the floor. Yeah, easy.
Did you make a motion, Mr.
No,
Rice?
no.
Oh, I'm sorry.
Before we proceed, I'd just like to point out, as Mr. Gabby did earlier, that as Mr. Berman said, this came up, this application we've heard before, we've heard in the past. The last time that it was here, we recommended that the number of units be cut back if at all possible. And apparently the applicant felt that it's not possible to cut back the number of units. That being the case, if we felt last time that there's too many units, what changed? Why should we prove it today, the same number of units, if we didn't? I'm talking to the board and I'm talking out loud. I'd like to have the board's.
Going against it, that's part of the
But look at it, you have here less than half an acre on 11 families. That's my point, I'm just making a point. Coming back.
Someone has to make a motion.
Nobody made a motion here, I understand that. I'm just raising up the point that why this came back tonight, we heard this already, the reason it came back, we expected to hear it again. With less units, it's coming back the same number of units.
Yeah, I'm sorry, Mr. Chairman, if I may again. I wasn't here at the last meeting, so I can't tell you this from my own knowledge, but I'm being told that it wasn't recommended that the number be reduced, but it was recommended that the unit be made smaller. I can't say yes, I understand.
I respectfully disagree with that assessment. The way we envisioned it, and the board can correct me if I'm wrong, we recommended that they cut back the number of units. It was 10 units in 1/10 of an acre.
it was also, the whole time, the owner kept on saying that it's going to be owner occupied and that's what's plus. The owner just stood up and said that she's going to be moving. And this is in essence,
Oh, I
a
said
development.
last time my
This is
children.
not, this is a development. This is-
Vote to reduce.
Okay, be that as it may, I'll entertain a motion to, if anybody wants to make a motion to grant sketch plan.
Subject to the CDRC report with the deletion.
No, as it is on this application.
You can grant sketch plat whichever way you want. If you grant it with less units, the applicant has the right to go to court, or he can proceed to the ZBA, whatever he does.
Anybody want to make an application? Sorry, your motion.
Motion to grant, to cut down the two apartments and grant.
No, it's to the,
And bring it down.
building number one should have one accessory instead of three
So
accessories.
you say 3-1 and 3-1.
3 and 1 and 3 and 1, correct.
And bring down maximum development coverage to point
I
five.
am not seconding the motion.
You didn't say that, that's not part of his motion.
Motion is to bring down two.
Well, that means that the whole, there'll be some greenery.
Was that, cut back,
It's already, the other one's already been discussed.
okay, one second, the motion is to cut back to 3 and 1, 3 and 1, and to grant sketch plan approval. Okay, so there's a motion on the floor to grant sketch plan approval on the condition that the units are three units and one accessory in each of the two lots. Do you have a second to that motion? Second by Jose. Anybody opposed? I see one. All those in favor? Passes 5 to 1.
Mr. Chairman, can I ask, did the board consider trying to deal with the scenario other than what was proposed here, that you consider 3 and 3 and 3 and 0?
Can you say that again?
In one building, 3
that's
apartments, 3
9,
units
that's
and 3 accessories, and another one,
Still
3
nine.
units with 0.
That's still nine, that's not three, it's three.
Nine.
Seven, eight, nine, it's nine.
Remember, there's no guarantee you're going to get 2 units, additional units on lot 1, because if they don't have the
You
required.
have to go to ZBA, you have to go to
Right.
ZBA.
Right, no, I'm just making.
Mr. Rice, can I ask you, you don't
Well,
have to answer
someone have
me.
to,
What is the rationale?
We'll find out.
Was the public hearing opened when Mr. Mace was
It was
allowed to
closed.
speak?
Is representing the applicant?
I think that that way they can have units that, unit sizes that'll work better for the families that live there.
It's still 9 and that big.
when you have a motion that's
Doesn't
passed,
pass.
so someone would have to
Amendment or change?
make a motion to rescind the resolution and then make a new motion.
Anybody want to rescind and change? No, it doesn't seem like. The board wants to stick with its decision of 3 and 1 in each of the 2 units.
And now you need a motion.
Motion to ZBA, refer to the ZBA.
That's my
It's bring down.
opinion is always that the ZBA do what they want. I don't think that-
No recommendation.
No recommendation.
No
Make a
recommendation?
recommendation that the ZBA bring it down to
No.
point
No,
five.
no, no, no. It's favorable, not favorable, because not favorable, they can read into it that they're going, that you're not in favor of even the applications that the variance is the applicant. You don't have to put in a reason why you are not looking.
Okay, so there's a motion on the floor to refer to the ZBA with no recommendation by Yaakov Ash. Anybody, is there a second? Seconded by Jose. Anybody opposed? Any abstentions? So it's passed 6 to 0.
Thank you.
Next. Next item. Next item on the agenda is Grove Estates. Quiet please, this public hearing, the application of Grove Estates, LLC, 8 American Street Valley, New York, for sketch plan approval and final subdivision approval with respect to drawing title for Grove Estates, consisting of a 3-lot subdivision with a 2-family dwelling on lot 1 and 2-family dwelling with 1 accessory apartment on lot 2 and 3 and 0.95 acres. How many questions located on North Side of Grove Street, approximately 200 feet east of Dempsey Avenue, which is known as tax map section 56.10-3-28 and 29 in an R15A zone. And who represented that?
Terry Bryson, and so
Right, the floor is yours.
thank you.
Before you proceed,
Yes,
we have the affidavits of posting and notification and the publication and receiving.
Thank you.
You're welcome.
This application involves 2 lots consisting of 0.95 acres in an R15A zone. The proposal is for a 3-lot subdivision. There was originally before the board a proposal for a 3-lot subdivision with 2-family and 1 accessory on each of the lots. The planning board denied sketch plat approval. This proposal was changed in that the proposal is for 2 2-family dwellings and an accessory apartment and 1 lot with only a 2-family dwelling.
Excuse me, one lot would have only.
1 lot would be only a 2-family.
And the other 2 lots would have.
The other 2 lots would be 2-family with 1 accessory on each. Okay. Before I go further, I would just like to say that we would hope that we open the public hearing and can continue this to the next meeting for a number of reasons. One, as you can see, I'm new to this application. Secondly, I believe the applicant is still trying to work out some of the potential issues with the neighbors. And thirdly, and very importantly, because some traffic concerns were raised by neighbors, the applicant has hired Harry Baker, and he's done a traffic analysis. He was not able to be here tonight, but he would be at the next meeting.
So why are you here tonight?
I'm sorry?
So why are you here tonight?
He's not here because he's away.
Why are you here tonight?
So we can explain the application, and there are a number of people from the public that would like to be heard, so that we thought they could be heard, and then we can go from there.
Correct me if I'm wrong, with respect to the traffic, that was not discussed, that you were hiring, I don't believe, correct me if I'm wrong, Mr. Baker at CDRC. So otherwise, that may have been an issue why we advanced the applicant to adjourn, but we didn't know about that. We thought this application, had they provided all the information that we requested, and this matter was ready to proceed. So we're first hearing about the issue that they hired a traffic engineer, Mr. Baker, and he was out of town, so therefore cannot, cannot submit any reports to you.
But besides, let's forget the traffic issue for a moment. What about other issues? Are there other issues that are open?
Say again?
Forget the traffic issue for a moment. Are there other issues that are not ready to be heard tonight?
No. We, CDRC, believe, based on what we discussed, this application is ready to come to you for discussion.
And we're ready to proceed. My only point was that we would like to leave the public hearing open to the next meeting so that Mr. Baker can be heard to satisfy any issues that the neighbors might have with respect to the traffic, so the applicant can continue to work with the neighbors, and so that's, I got this file today, so that if there's any other issues,
I thought you said a moment ago, correct me if I'm wrong, that you would like to hear this, then adjourn it. One of the reasons I believe you said was there are certain issues that still have to be resolved.
No. They're still talking to the neighbors.
They have some resolve certain issues that the neighbors have. In other words, basically, you're not ready tonight.
No, that's not what I said, Mr. Chairman.
That's my conclusion.
Let's deal primarily then with the issue of the traffic, because that's the main concern. I would like to make our presentation, hear what the public has to say, and then at the next meeting, Mr. Baker can appear and explain the traffic, because the town wasn't so concerned with it, but the neighbors were concerned about traffic, and that's the primary issue I was referring to, the neighbors that were concerned about traffic. The applicant went on his own and incurred the expense of hiring a traffic engineer to satisfy their concerns.
Mr. Berman, you come back to me if I'm wrong. I believe we've had this come up from time to time, quite often, unfortunately. It's with the position of the board that if you're not ready tonight, goodbye. We don't have to hear it twice. We don't have to, because Mr. Rice, you know as well as I do. If we hear it tonight and we adjourn to the next meeting, 2 meetings from now, whatever it is, we're going to hear the same stories over and over and over again. basically taking up 2 nights of the board's time.
If we can be on the next agenda, then I have no problem doing that.
Then what? Then what? Finish your sentence, please.
I said if we can be on the next agenda, I have no problem with the board handling it that way.
August is full, and you adjourned several contentious cases on August meeting.
Mr. Klein, the people in the audience that came out are all housewives. They came out last time, sat here for hours. They're here again. It's just wasting their time. If they're the neighbors, they live there. And
So what are you saying? So what are you saying?
it's not fair to them. If they made the time to come out, then
It's not our fault that the applicant isn't ready.
so that's why it's not fair, but the applicants are doing.
But the applicant is doing
The
something.
neighbors. It's not, it's why the applicants are doing it.
With all due respect, we're more than happy to
Shh,
proceed.
can we have quiet, please?
We're more than happy to proceed. We're more than happy to hear what the neighbors have to say. My only point was that, particularly because Mr. Baker couldn't be here tonight, we would like to take all the testimony and then just adjourn to the next meeting so that Mr. Baker can make his comments and then we'll be finished.
But Mr. Rice, I want it understood. If the board agrees to do that, if the board agrees to your request, I want it understood that come the next meeting, or whatever the next time that this is heard, I will cut people off if they keep repeating things that we heard tonight.
That's fine. I understand that completely.
I want it clearly understood, and I don't want to be accused of cutting people off. Because we don't have to have 2 meetings for the same application because somebody's not ready, which is not no fault of our own or no fault of the town.
And again, I don't want to get argumentative, but I mean, we're ready. It's just that Mr. Baker could not be here tonight.
Then you're not ready, okay. Anybody else want to have any comments on this
Yes, I feel
discussion?
it's not fair to the neighbors because they're gonna have to come out again and.
So what do you say?
and to
What do you say?
testify.
We should or we should not hear it tonight?
So either we just say, I'm so sorry, Mr. Rice, your traffic person is not here, so you will not get that option.
We will not get
The
the option.
applicant has a right, if he, let's say he didn't bring that up, he could go to an hour meeting and say, I request an adjournment of the public hearing to continue to respond, including Mr. Baker. He was up front and said, he has a traffic eye, apparently that's it, we didn't know about it until tonight, that's an issue. So he's saying, if you want to adjourn to the next meeting, which cannot be done because August is packed, or he's saying, he'll make a brief presentation, we'll discuss it, hear from the neighbors, and then adjourn it.
Okay? Ariel, what's your feeling on it? Should we hear it tonight? Leo? Leo? Yes.
Do we have the option of closing the public hearing?
When? Now we didn't open it.
Yes,
No,
We didn't
that's-
open it.
That's unfair. If an applicant at the end of a public hearing asks to continue to adjourn so he can respond, to me is unfair and would be very difficult to justify in a lawsuit that when the applicant says, I still want to make time. So I would think you can,
but he has all the time he wants tonight.
I understand that, but he's making the point, there are comments that were expressed about traffic. They have decided, subsequent to CRC, because we didn't know about it, or we would have said, no reason to stay on, because we haven't seen their traffic, let alone you guys have seen the traffic, or the neighbors have seen the traffic. He has the right to make a presentation. I think it would be unfair if he has a presentation and said, no, you had your time, you can't put in your proof. You can never guarantee what a court's gonna do, but I believe we would lose that lawsuit because we didn't allow the applicant to make his complete presentation.
But they made the presentation.
Okay, okay. Leo, what's your feeling? Can't hear you. Next week?
Last time at board meeting, we also came out, they weren't ready, after we got down to 5 weeks like we can. Didn't hear it. I know it's hard for the people to come out again, but to come out now and come back again, it's everything over and over again.
I'd like to speak on behalf of the neighbors.
Ralph, they don't hear.
Why didn't the traffic arguments? But you did traffic consulting, and that's before everything.
Zay, what's your feeling?
We don't want to talk.
We're not trying to drag the neighbors out twice. I mean, I said, I'm more than happy to
I
make
think it's unfair to have the neighbors come out again if they can. They have to play. That's why.
And anyway,
the feeling of the consensus of the board seems to be hear it next time.
I'm sorry?
The feeling of the board, the consensus of the board is to hear it next time.
And we don't have any problem doing whatever works best for the board, but we would request to be on the August agenda.
Well, if the August agenda is, unless, are we considering putting in a second meeting in August?
But you can't do that, because the people don't have the knowledge of when that meeting is.
Why don't we just make our, I don't want to argue, why don't we make our presentation, the neighbors are here,
As a neighbor, I have a statement.
No, sorry, the public hearing is not over at this point.
Not your turn.
Mr. Rice, you've been around a long time, I'm sure you know. This is not the only case we have like this.
Of course, I would have been done, but
This comes up time and time and time again, and the board is getting fed up with the fact that something is scheduled, and at the last minute, something comes up, and it does come up, and things weren't presented, provided on time, whatever the case may be, and we have to give it a second. The board, as you hear, the agendas are full as they are. We don't want to have to waste needless time hearing things twice, hearing the same. But the feeling of the board, I'll entertain a motion to adjourn. Huh?
You do it in August, it goes to the end of the agenda, we have an 11 o'clock rule.
I didn't say, we'll adjourn it to the next available meeting.
Which means they have to re-notify everyone.
Can I hear a motion?
Mr. Chairman, just so you understand, Mr. Watchall had emailed Mr. Baker on a number of occasions, and just so you understand that there's no disrespect to the board, to be here when we first received the agenda that it was going to be on tonight, and it was not until today that he found out that he was out of town. So, you know, we also went to the this was not something that the CRC or the board required. This was something the applicant volunteered to do to try and ameliorate the concerns of the neighbors.
The bottom line is, we have to hear it twice. I'll entertain a motion to adjourn this until the next available date. This motion. There's a motion on the floor by Jacob Bach to adjourn this to the next available date, seconded by Dr. Levy. Anybody opposed? Any abstentions? Shows passed 5-1.
Oh, you want to stay?
Next item on the agenda. Quiet, please. This public hearing for determination of potential environmental impact of 261 CR, about 617 of State Environmental Quality Review Act, and revised findings and approval with respect to the application based on 50 Slim Avenue, Street Line, New York, behind temporary school phase number 1. Can we have quiet, please? Phase conduct consisting of a phasing plan with the use of 2 temporary modulars and an existing dwelling as phase 1 during construction of a permanent school phase 2 on 1.43 acres. The property in question is located on the east side of Slade Avenue, approximately 300 feet south of Hickory Street, which is only designated by tax map, section 50.18-1-2, and R15 zone. Mr. Rice, I think you've seen more tonight than the whole year. Welcome back.
You gotta get my average up on now.
I'm not sure you're gonna want to come back after that.
I'm not gonna touch
Play the role of Ryan Parker.
that. I'm not touching that straight.
So we good for him?
Kerry Rice and Anthony Salvatano again. As you know, this is an application with respect to.
Please, 1 second. Gentlemen.
Thank you. For a girls' school, it was previously approved, as I'll discuss with you. The property consists of 1.5 acres. There's a school for 140 girls, I believe ages 5 to 2026. School operates Monday through Thursday from 9 to 5, and on Friday from 9 to noon. There are 6 staff members. A total of 3 buses are involved in the transportation. There's no kitchen on site or outside catering. And there are no violations existing on the property. The property obtained a temporary modular approval for conversion of an existing home and the use of two trailers in 2013, and the trailers were installed in 2014. The permanent site plan for what we're calling now Phase 2 was under review, and final approval was received on August 31st, 2015, and the applicant is still awaiting signature of the subdivision plat, site plan rather, because it's been going back and forth with DPW, working out all the details and concerns that the DPW had. So as you can see, it took a significant amount of time to get from the start to the finish. The applicant is very hopeful that they'd be able to get a building permit in the very near future and to start construction. So they're requesting a 2-phase here. Phase 2 essentially has already been approved. Phase 1 would be the existing house and the trailers, and they would like to get approval to use the trailers for 30 months. They're also requesting a waiver of installing the landscaping at this point in time, because when the construction starts, there will be destruction to the landscaping by virtue of the construction, the vehicles and so forth.
Mr. Hackett, just interrupt you for a moment. You said there are certain approvals. Phase 1 has been approved.
Phase 2 has been approved, the permanent part. So the trailers and the home that's being used as a school is what has been coming in for Phase 1, and we're looking for the ability to use that for 30 months until the Phase 2, the actual long-term construction is approved.
Why is this up for negative?
Because the original negative declaration was based on just the construction of a permanent school. Now they want to continue to use, and that's why it's a new secret determination.
Okay.
And there are some implications in some of the reports that the applicant did not proceed with all due haste, they didn't act in good faith, and were just using this as a subterfuge in order to use trailers and never build the permanent housing for the school. That certainly is not the case. The applicant has proceeded as quickly as it could under the circumstances. It takes a long time to go through the review process. It takes a long time for the check prints and all the checklists to go back and forth and get approved by the various agencies. And the applicant is fully committed to building the permanent phase and is looking for the assistance of this board and able to continue using the trailers, which they've used for almost 2 years at this point without any issues or any problems.
I'm so sorry, I didn't hear something. They've been using these trailers for
Almost 2 years.
2 years?
Yes.
And they want to use it for how much longer?
Well, we're requesting 30 months at this point.
How many?
30 months
30 months.
until the permanent facility is completed.
Okay, let's go through the CRT. Let's go through the CDRC report. Dated July 20th, 6 points, 3 bullets.
Yep.
Got the right one, Mr. Berger?
Yep.
DPW dated July 14th.
I have no issues with any of the engineering requests.
Building inspector dated July 26th.
No issue.
One question is, the building inspector right here says you need a waiver of the buffer for the Phase 1, and our code says you can waive buffer if you provide substitute landscaping measures. The applicant has stated he doesn't want to do any landscaping. So that's a problem because when you waive the buffer, if he's not giving you any substitute measures. That's what our code says. If you waive the buffer, provided you have substitute landscaping measures.
So,
If
no
I
fence
may have that
around.
issue, because it's temporary in nature, they can put a fence up with screening, provide screening until the permanent facility is correct, and the landscaping is.
So, well, that's a fence?
It's up to you.
It's not, technically, it's not a buffer. A fence is not a buffer.
No, it's either a buffer or something in lieu of the buffer.
Oh, okay.
Whatever that something is.
So you want a fence, 6-foot high fence?
Yeah, it's fine.
Yes? What kind of fence?
Whatever kind you like.
Who lives next
White
door?
vinyl fence?
Sorry?
White vinyl fence?
Yes.
And where would you propose that fence?
Along the side of the lot.
Just over here?
Okay. Fire inspector, would you like
Whoa, whoa, whoa,
one?
what about
Sorry.
that the person who lives at the other side is seeing parking spaces without any screening? Are those, Mr. Selkan, are those spots to the north, are they gonna be in phase one?
Yes, but the cars will be facing in towards the school.
Doesn't matter, you're still gonna see cars.
More than 5 spaces, you must have screening.
You have to put screens up whenever there's neighbors involved. Okay?
No, up to the property line?
No.
I mean, that's a temporary reason. He says
Here,
it's-
Sorry,
doesn't the school
not
require,
10 feet.
doesn't the school require 2 acres? You were requiring 25,000 square feet.
Not in this zone.
On this zone, the school could be on
15,000.
15,000.
No, it's not.
25,000 over.
So they've already got approval.
Right, I don't know.
Once again, if you want to speak, please give us your name. Otherwise, let them speak.
The schools require,
And the fence is where the parking is fine.
in this zone, you're allowed to have school on how much of an acre?
I think, I don't have to go right in front of you, but for what I recollect.
The minimum area is 25,000 in this zone, they have.
But based on number of
Based on number of
students.
students.
Right.
I'm under certain.
Based on the number of students in the zone.
Let's finish the CDRC reports, please. Fire inspector letter of July 20,
No issue.
no issues. Fire Deputy Clark letter of July 19,
We also had a comment about the landscaping, but the fencing would be inadequate.
yeah, be okay with that? Okay, fine. Shh. Rockland County Sewer District number 1 letter July 18,
No.
no what? No what? No problems? No problems. Rockland County Health Department letter July 14.
We'll comply with that.
Chairman, members of the board, I'm discussing something with the building inspector.
Yeah, I can hear that.
But you didn't hear what I said. They're proposing a 13.3 side setback for the trailers. Since, even though this is only there for a month, or whatever time, 30 up to 30 months, it's my opinion, he makes the final call, that they either need to move the trailers out of that area, because it's technically final site plan approval for a structure that it has to comply with the setback, and the setback there is, required 20, so they need to move it 6.7 feet, or they need to go to the ZBA and get a variance.
You move them?
It's a permanent structure, even though it's only temporary, it's final site plan, it's not under the modular law, which allows you to, the building inspector can waive setbacks, he can't waive yard, so it complies with the yard, but it does not comply, technically, this is, phase 1 is this building, and phase 2 is not. In my opinion, I think we've done it before, that you have to comply with all the bulk requirements to get a variance.
We'll talk to the building department about that, and if necessary, we'll apply for variance.
You will either move it or go for
Apply for
variance.
variance, one yes.
So the map cannot decide until that determination is done.
Rockland County Health Department letter July 14.
No?
That's not, no issue on that.
No issue then. Okay, CDRC recommends against waiver required landscape, we went through that. Applicant requested waiver of buffer, we did that. Scheduled July 26th meeting. Okay. Comments or questions from the board on the application of 50 Linden Avenue?
Yeah, so, can you,
Okay, let me-
for 1 year with an extension by the building inspector for a second year.
Was that given for the second year?
No, once they come to you, you can grant them anything they want. Our temporary module law only allows them 2 years.
So
They're at the end of that.
That's
So
why-
they're coming
that's
to
why
you
we're here.
to get away from the, not even extension, it's not extension, you guys are giving them a phased plan,
Right.
which I can't do. My authority is for 2 years temporary, and that's it.
And you already have started one action, and the applicant showed something. We have another action, Klausenberg, where it's beyond the 2 years. You granted an approval, but we still brought an injunction action to enjoin them from continuing to operate for those 2 years. So we could, again, it would be up to the ultimately the town board whether they want to go to a grant authorized an injunction action because they're beyond the 2 years.
We're not beyond 2 years.
Oh, they're not.
No, we're not beyond the 2 years yet, so that should be clear. There's no violations here. They came to you and to the town to try.
Or there are no violations?
No violations. No. And the 2 years is not expired.
So you're asking for a 30-month extension?
No.
Well, it's not an extension.
We're just asking for 30 months in modular units
For phase one.
for phase 1,
Right.
which you grant, if we didn't have a modular law, you can grant temporary use as a phase for any development anywhere. That's what they're asking for. They're asking for 30 months, the way it is right now, modulars and that home is a school, and then after 30 months, they'll have a permanent building code in there. It has nothing to do with the temporary modular law at this point. That's gonna be over soon.
So what if they don't have the permanent building there in 30 months? What happens?
There might be a violation, they're in violation, and we go for another
So
injunction.
this phase 1 cannot be permanent, it's only.
It's not
It's
permanent.
not meant to be.
Phase one, and they specifically put that on completion of the permanent school,
That would be
removed prior to even getting a CFO.
Right.
That would be a condition of any.
Absolutely.
All right.
Any other comments, questions from the board?
Yes. I want to understand this, can I understand the zone? You said that in this zone, it's based on the number of students.
Why is it only 25,000 square feet?
That's what the 25,000 for. The requirement is 25,000 square feet with the number of students. that you-
How many students do you get?
This was, I thought it was always 5 acres for the small.
You were like under that.
I'm dating myself?
Yeah, you were like under that. During the comprehensive plan, the town board in its wisdom decided to reduce the lot area for schools and based it on certain zones based on the size of the number.
Right, and my understanding is that under 150 students, the minimum lot size is 25,000 square feet. Over 150 students, it's 50,000 square feet.
Right.
And this was approved by the board, so I mean, it complies.
This is approved, this is approved already.
And they didn't need variance.
They didn't-
So under 150 students, is 25,000 square feet?
Under 150, I understand.
Okay, any other comments from the board, questions from the board? Okay, this is a public hearing.
Mr. Chairman, if I can, just so there's no confusion, the permanent facility has been approved by this board. That's what we're calling phase 2. That's done, and we're trying to get in the ground.
Phase 1, you can try to get a phase 1. Okay, and this is a public hearing, anybody from the public wishing to speak on the application, 15 Slim Avenue. Anybody from the public?
I would like to speak.
My name is Deborah Munitz. I live at 5 Rose Hill Road.
Deborah Hughes,
Munitz,
address, can you please?
5 Rose Hill. I was actually at the CPRC meeting on the 20th. And I want to convey 2 different things. I want to talk about what I saw at the CPRC meeting, because what I heard at the CPRC meeting, which I brought a copy for the board, was not reflected here tonight. There was absolute feelings of aghast from the attorney, from the DPW, and even Mr. Manley used the words crazy with respect to this particular application. So I think it's really important to understand that this is not the intent of the laws. Schools in the town of Ramapo, for every single residential unit, fall under the need for a special permit. Only you give the special permit. This particular temporary modular law, I would say, has been used illegally to date. It's not right to turn around to the neighborhood and suddenly change, fundamentally change the use and implementation of what is going on in a lot without having public hearings, public participation, referrals to other agencies. The idea that the building inspector alone can issue this is something that was not intended by New York State zoning law. I'm not talking about local law, I'm talking about New York State zoning law. The fact is, this law has been in place, and when you look at New York State zoning law and you look at the town of Ramapo law, there is this concept of staging. Even Alan admitted that that was his idea, okay? He had this intent. And I will be the first person to say to you that if someone comes to you, goes through SECRA, goes through the entire process, and says, here's what we want to build, okay? This is our plan, but we need 2 years to get there, or a year to get there and get the building, permits. We need to put in the infrastructure, because even the temporary modular laws need the infrastructure. They need the SECRA, okay? You, as a planning board, are responsible for making sure that things happen in a rational plan phase with public participation. Now, what's happening is they've taken advantage of one law to do something that I would argue should never have been done in the first place. And yeah, he's shaking his head because that's absolutely the opinion. But that was the opinion.
You will make your point, and I
That
will
was
respond
the
in
opinion, and I will give you the CD about
I'm
this.
shaking my head, unless it's on camera. I'm shaking my head.
What I'm saying to you is that this happened, and it's time. You guys granted them a site plan. It is time for them to move on to the site plan. You can't reward people by doubling down and having them take advantage of one law, only to go on and doing things that the public never had an opportunity to participate in. Okay, this was not the intention. So if you go, it's not like they're saying, oh, we need 6 more months, or we just got the bill, or we need 6 months from the time that we get the final building inspection. They're saying, we want effectively 3 more years. So everything's going to continue, the neighborhood's going to continue to be affected. Now, what's to stop this applicant, okay, from saying, I want another revised final site plan? That's what they're asking for today. They want to revise, and they can keep doing that until they go and actually start developing the site. And never build it, continue influencing the area, possibly, buy more lots. It's a misuse of the concept of good secret, good phase development. And I am telling you that I did not see anybody in that room last week who was in favor of this. This is just a miscarriage of justice. And I agreed to come out tonight and make these comments for myself as a citizen and resident of the town of Ramapo, because I believe that when you do your job right, I may not like the results, you may not like the results, but at least we've optimized the results. And we've at least had the opportunity to get involved with our voices, legally if necessary, and to basically sidestep and then just double down on it is an absolute travesty. And I'm saying to you, tell them to implement the plan that you guys approved. It's time.
Thank you. Anybody else from the public?
Hi, my name is Teresa Bullock.
What is that? Speak up, please.
My name is Teresa Bullock. B-U-L-L-O-C-K. Teresa.
Okay.
27 East Hickory Street. 27 East Hickory Street. I live approximately 3-4 houses away. I would request that the board adjourn this so that I can obtain counsel, legal counsel on this. I'd like a lawyer. I want a lawyer to come in and help us with this issue. So I would appreciate it if you, huh?
You would like to hire a
Yes,
lawyer?
thank you.
Okay, good.
Before you vote on this. Okay? I want an adjournment. That's basically what I'm asking for.
We hear you.
Thank you.
Thank you. Anybody else from the public wish to speak to this application? Anybody else? Mr. Rice?
My name is Gabriel Rosenberg. Gabriel Rosenberg, G-A-B-R-I-E-L. My home address is 7 Hammond Street. I am Hammond, H-A-M-M-O-N-D, M-O-N-C. I am the administrator of this school, and I take on top of this project. On September 1, 2015, which is less than a year ago, we were here in front of the board, and we had a public hearing about this project, and nobody opposed this project. We didn't ask for any variances, and if I remember well, Mrs. Gabioff was in awe how a school will build today without any variances, and there's no need for variance, and we wouldn't go out anything with the boundaries that we're supposed to do. And we got all the rules of it. We're here tonight because this has been going back and forth between our engineer and the Department of Public Works. We'd like to get this done as soon as possible. We actually have a large, most all of the funds ready to get started as soon as we get the final approval signed. Whichever department needs to be signed, it's ready to be, we're ready to go ahead and build this. We would like to see this built before anyone else. We do need this existing, we do need what we have now for the time that we do the construction. I do have to make a point that the existing structure, whatever it needs, whatever we have now there, meets all the fire codes. We took no shortcuts when it came to bring it up to the code. The building inspector and fire inspector, they come down once a year. They had no counts, nothing what to, it met all the codes. And we're not looking for any shortcuts in the future. If we have to put in the fences to the side to create a buffer, we'll be happy to do that. All we're asking is, we need place for up to 140 kids for the next, hopefully less than 30 months, but we're asking up to 30 months. Please give it to us. So there's nowhere to turn. There's nowhere for schools. There are no other schools there to go. We hope to have the structure up as soon as possible.
Thank you.
Can I ask you, what is the reason why you're not moving on straight to phase 2?
We are moving on. We are
Why are
actually
you asking the 30 month, why are you asking 30 months of?
just takes time to build. We don't want to come here back every year. You know, it just takes time to build. Whatever it is, we're ready to move ahead as soon as the engineers do it. No, it's not. We're working 11 months and we're getting all the details. Right, we didn't have any blueprints. We were working the blueprints. You're building a school. You're not building. You're building a school which lasts for quite a while. We're building a block structure. We were working the blueprints again and again, and we hope that the blueprints are done. We hope to move on as soon as possible. We don't even have room to be there. You know.
Is it possible that the landscaping is offensive to the neighbors?
We were not. If we have to
picture
do.
of, you know, like, can you circular driveways, could be that you could plant grass?
Sure. There is grass right now in the front. And we have to make another point. We went away and we put in these catch basins for the temporary, so there's no, which will not be used now in our permanent building. But we made sure to put it in even in our temporary phase, so it doesn't pose any issues to the neighbors. If we have to do any more, whatever we need to do, we'll do.
In your circular drive, do you still have up the black plastic?
No. Thank you. Anybody else from the public on this application? Mr. Rice, wish to respond?
Thank you. I don't wish to belabor it, but, I mean, I think this is the type of applicant that the town wants to have. They've come in from the get-go, and despite the innuendo and implications from a couple of people, they haven't abused the process. They've tried to work within the process, and as was observed, I mean, how often do you have a school that comes in and doesn't want any variances? They've done everything right. They don't have any violations. They've applied for this prior to the expiration of the 2 years. And part of the problem in getting a building permit is the fact that they're still trying to get the write-off from DPW. It's the internal administrative thing. It is at least part of the problem here. So there's no question that they will, as expeditiously as they can, construct the permanent part of the project. And this is something they just need to bridge them to get to that point. Thank you.
Thank you, Mr. Ross. Mr. Vernon, you want to say something?
First, with all due respect to Ms. Munitz, I only write the law that I'm directed to by the town board. I joke around, say it's my law because I helped draft it, but the law was at the direction of the town board, not myself or the town attorney's office. Nor the building department. Number two, whether I agree or not, the original intent of the temporary modular law was the applicant to have 1 year and maybe an additional year to get approval and build it. Some, I don't know, 1 or 2 maybe have either removed it or have started building, etc. They also have the right legally to make an application to revise their site plan to make into a phased approval. So Ms. Munitz is right. They're using one law and they're using a second. They have every right to do that. Number 3, this was the subject of a public hearing originally back in 2015 and is the subject of a public hearing as well tonight. The issues she raised about special permit relate to the validity, and no court has determined whether it's legal or not, whether the town can, whether the building inspector, after consulting with CRC, can grant a temporary approval for temporary modulars without a secret determination or without a special permit. So that's not related to what the application here tonight. The application is for revised site plan approval. Special permit doesn't change. Revised site plan approval. We have secret determination recommendation from the planner. We've had a public hearing. So with respect to this specific application, we're complying with both the state law and the town's local law in terms of how you consider a revised site plan approval.
Thank you. Okay. There's a motion by Yaakov to close the public hearing. Is there a second? Second by Dr. Delio. Anybody opposed? Vote is passed 6-0. On the first order of business, neg deck.
We are recommending a neg deck based on our review of the environmental impact.
Okay. There a motion to grant the neg deck for the application of 50 Slim Avenue. Motion by Jose to grant the neg deck. There a second? Second by Leo. Anybody opposed? Any abstentions? Vote is passed 6-0. Revised final site plan approval.
Well, let me see what conditions you discussed. Subject to the CDRC with the deletion of DPW comment number 1. Addition of white 6-foot high, white decorative fence.
Decorative? Why pick a fence?
To screen screen phase 1 on both north and south side of property. And no signing of the map until the applicant receives a variance for side setback or moves the temporary modular units. I believe that is it.
Okay, anybody want to make a motion grant revised final site plan approval as per together with modifications as discussed. Motion by Ariel, second by Jose. Any opposed? Any abstentions? Motion is passed 6-0. Thank you.
What about the chairman?
They
Whoa,
not-
whoa, 1 second. Whoa. I missed it.
They
You have to amend the motion. Are you waiving the
They
vote?
blow me off?
Yes, yes.
You have to amend the motion to waive the vote.
So it's not put in its place.
Right, you're waiving the vote.
Are you not considering my adjournment?
Will be considered and decided against it.
I'm sorry?
It was considered, but was voted against it.
Thank you.
Yes.
Can I say something?
No.
The public hearing is closed.
That's
The
something
public hearing is closed.
It's not about this.
The public hearing is closed. It's not, there's no general comments to the hearing.
You could talk to him,
So someone has to make, to amend the motion to, make a motion to amend it to approve waiver of vote.
Yeah, I'm all right.
Yeah, the vote is closed.
Leonard Jackson. Leonard Jackson.
We'll just see what's good.
If you want to send a letter, you can send it and you'll be in the file. The public hearing is closed. You can't even send stuff after the public hearing.
Okay, Mr. Jackson,